Welcome to Ganja Law 101, Episode 5. I'm going to cover the same period of time that I covered in the last episode, from 1970 through 1990. And while I was getting arrested, there was a lot of legal action going on, and we got the assistance of the National Organization for Marijuana Laws, Reform of Marijuana Laws, to help us and get some expert witnesses and attorneys, and so a lot of things were going on during that period of time besides our court trials. And of course, everything became clear that marijuana was a poor fit for the Schedule 1 in the Controlled Substances Act. Didn't belong there to begin with, and just became more and more evident over the years. So as I left the last episode, I was talking about the decision in Employment Division versus Smith. And that was a case involving a couple drug counselors in Oregon who were using peyote in religious ceremonies and got fired from their jobs as drug counselors. And the ruling in that case was that the First Amendment did not protect the use of peyote, which caught everyone by surprise. Like most people, I thought that the 1964 decision by the California Supreme Court in People versus Woody correctly applied the First Amendment of the U.S. Constitution to the religious use of peyote, which the U.S. Supreme Court said it did not in Employment Division versus Smith. And I thought that my equal protection argument failed because peyote is not cannabis, which was sort of not quite exactly correct. It comes close to the mark, but that's not it. So neither of those assumptions were correct. The federal exemption for peyote is a regulation, not a statute, and it's not a federal court decision. So it is not a ruling on the First Amendment. And it wasn't created because of the First Amendment directly. I mean, you can assume that was the motivation for it, but that's not how regulations are created. There is no provision in the Federal Controlled Substances Act for the religious use, but there is language that allows an exemption that reads exactly like the federal exemption for peyote reads. People supplying the peyote to the church must register. So those people are not members of the church, so there it is. It's not a religious exemption. It's for a religious organization, but the exemption itself is for a secular business activity. And so that leads me to the second point. The religious use of peyote is regulated, while the religious use of cannabis was not. So that was the difference. I was trying to think that there must be some difference in the way that peyote is used and cannabis is used, which is true because one's regulated and one's not, so that's how it's being used. But it's the regulation of the supply of peyote to that church that did not exist for cannabis, and to this day, the federal government does not recognize any use of cannabis and does not regulate any kind of cannabis business. So those things, it wasn't clear to me back then, but it's cleared up to me for me now because Iowa has begun regulating cannabis, and I can see how that's exactly the way that any controlled substance has to be made legitimate. If it's not for medical or scientific use, it has to have some kind of an exemption attached to it where they waive the normal condition that it be for scientific or medical use, because the production and distribution of peyote is not being done for scientific or medical use. So going back to 1970 when this stuff got started, the first thing that happened was they created a commission on marijuana, and it was called the Nixon Commission by some people, but that commission decided that an effective discouragement policy does not require making private possession of marijuana a crime, nor does it recommend putting users in jail. Now that was kind of ignored, but anyway, you can see that started there was controversy, and that just kept the controversy going because people just didn't think marijuana was that dangerous. And then, so what happened was that when that came out, the National Organization for the Reform of Marijuana Laws filed a petition to have marijuana removed from Schedule 1 and placed in Schedule 5. And the Drug Enforcement Administration made an objection. I think it was actually the Bureau of Narcotics and Dangerous Drugs, but anyway, the same thing. And they said that the single convention, which I talked about in previous episodes, an international drug treaty required that marijuana be in Schedule 1 or Schedule 2, and that they couldn't move it any lower than that without violating that single convention. So that generated an appeal, and that case in 1974 actually remanded back to the DEA for more clarification on what exactly this international treaty had to do with it, because that was a strange way to classify a controlled substance by deferring to an international treaty to make a decision based on that affects citizens in the United States. That's unusual. So then, while that was going on, the Supreme Court of Alaska made a ruling that the possession of marijuana by adults at home for personal use is constitutionally protected. So that's kind of like what the Commission on Marijuana recommended. That's what the Supreme Court of Alaska decided in 1975. And then another thing that happened was in 1976, Bob Randall, a glaucoma patient, was growing cannabis in the District of Columbia, and he was arrested for growing it on the balcony of his apartment building, and he raised a medical necessity defense and won. So he had a court decision saying that he could continue to grow marijuana on the balcony of his apartment building. So at that point, the federal government created a federal program called the Compassionate Use Program. It was an IND, investigational new drug program of some sort, investigational protocol, and they put him on it, and they gave him a prescription for a can of cannabis cigarettes, 300 cigarettes a month, and the prescription was to smoke 10 per day. Well, we decided that Bob Randall would be a good witness, so he was one of the witnesses in our case in Florida. And he also attracted other people to the program, and two of those people live in Iowa. George McMahon and Barbara Douglas were on that program, and they received those cans with the 300 cigarettes per month and a prescription to smoke 10 per day, which is really unusual. So the reason I'm emphasizing that is because one would presume marijuana is dangerous. How could that be? The federal government would actually prescribe somebody to smoke 10 per day. And why would they? Every patient, like none of these people had the same condition. It's like, but they all had the same prescription. Very weird. But anyway, so then by the time that was going on, Normal had gotten a decision from the DEA and didn't like it, and it appealed it again in 1977. And the DEA said that the international treaty required that cannabis be no lower than Schedule 2. So the National Organization for Reform of Marijuana Laws said, okay, let's fight. We'll fight over Schedule 1. Schedule 2 is better than Schedule 1. Let's go. And so in 1980, the D.C. Circuit got tired of waiting for the DEA to come up with a final ruling. Let's see, what happened there? I can't remember. Anyway, The court was unhappy with the DEA's position and ordered the DEA to refer the petition. Okay, I got it. The court said they didn't like this international scheduling thing, and they wanted the Secretary of Health and Human Services to evaluate it, in spite of the fact that that the international treaties predetermine the outcome. And they said because there's wiggle room between Schedule 1 and Schedule 2, that means the Secretary of Health and Human Services has to evaluate it and make a recommendation on which of those to go through. So that's in 1980. And then, let's see, I've got these things out of order, but anyway, well, not really. So the DEA held hearings all over the country, and then an administrative law judge made a ruling in 1988. But right before the administrative law judge made that ruling, the First Circuit in Grinspoon versus DEA made a ruling on the scheduling, saying that accepted medical use and treatment in the United States does not require recognized medical use in every state. Well, that makes one think that marijuana could have accepted medical use in any state, and it would have accepted medical use in the United States. That's what that ruling says, but of course that's 1987, and we didn't have accepted medical use in the United States until 1996, when California became the first state to enact it by voter initiative. But nevertheless, that made you wonder, it couldn't be FDA approval because it wouldn't require interstate marketing, because that would be accepted medical use in all 50 states. And in the United States doesn't mean everywhere, it means anywhere. So that ruling has never really been used for anything. It's really a fascinating ruling, but it's lied dormant and nobody's really played that card. It seems really relevant today, but anyway. We'll let that go here. So then in the cannabis rescheduling petition, the DEA administrative law judge said marijuana in its natural form is one of the safest therapeutically active substances known to man. So the reason I'm bringing up all these things about the danger involved, like the threat to public health and safety, is that in all of my criminal cases, there was no evidence that anyone was injured. And with the amount of marijuana that I was arrested with, if there was anyone that wanted to complain about it, certainly someone would have stepped forward and said, this has caused me grief in my life somehow. Mr. Olson is a threat to me personally. And I complained about that, saying that the First Amendment should be an absolute defense. No harm, no foul. And that's what everyone thought the standard was, because that was the standard the California Supreme Court applied in People versus Woody in 1964, that the First Amendment was an absolute defense for a charge of illegal possession of peyote. So, but obviously I missed something, because the federal peyote exemption is a regulation. It's not a statute. It's not a federal court decision. And so I was comparing apples and oranges without realizing it. The California Supreme Court was overruled in 1990 by Employment Division versus Smith, because the Oregon Supreme Court tried to make that same ruling, and the U.S. Supreme Court reversed the Oregon Supreme Court and said, no, sorry, we want you to rule on your state constitution. And the Oregon Supreme Court said, well, it's not protected by our state constitution. We don't find a right to use peyote for religious use. So the Supreme Court said that is the correct interpretation of the First Amendment. It does not protect the religious use of peyote. So that's been really rough for people to digest over the years, and but I'm not having a problem with it, because I want to see marijuana regulated at the federal level the same way it's being regulated at the state level, because right now we're saying that it's still a federal crime, and that's ridiculous. It could be a federal exemption like the one for peyote, where the suppliers are registered with the DEA and the requirements are waived because of the exception for public health and safety. That is what the peyote exemption is based on. It's considered to be a non-threat to public health and safety, and certainly a state cannabis program is not a threat to public health and safety, or the state wouldn't have enacted it in the first place. But I'll save that for future episodes. That's about it for this one. So in 1990, when I found out that my use of marijuana was not protected by the First Amendment, I had to think about that because that had been my only argument, and I had to figure out where I was going to go from there. And I'd made an equal protection argument based on peyote, which wasn't valid because peyote is regulated and marijuana is not. But today, marijuana is regulated by the state. Peyote was regulated by the state of Texas and by the DEA. Marijuana in Iowa is regulated by the state but doesn't have the DEA registration. But why not? It should. So in 1990, I stopped using cannabis, and I met George McMahon and Barbara Douglas, two people on this federal program receiving the 300 marijuana cigarettes per month. And so we got together and started an organization to try to get an Iowa medical cannabis law enacted. And I will save that for the next episode, because 1990 to 2000 is just full of stuff. And it's going to be a longer segment than I want to continue with this one. So we'll just break this one right here at the same place the last episode stopped, at 1990. And I'll see you next time for episode 6. Thanks.